Today, we'll be doing a legal case study that relates to negligence and duty of care. Chose these cases because we want to consider the important roles and responsibilities of the teachers in student safety. We wanted to highlight the importance of a standard of care in education, not just as guidelines, but as matter of safety and livelihood. The first is the Crown versus Nicholas Mills. Jeremy Perry, sadly, at the age of 15, without proper swimming skills and being unsupervised, ended up drowning in Algonquin Park. There was a hired lifeguard for the trip, and Mr. Mills gave Jeremiah permission to swim without a lifeguard after he demonstrated his ability to swim 50 meters without one. The Crown found that the preparation did not cause his death, that beyond a reasonable doubt, Mr. Mills' act of allowing Jeremiah to swim without a life jacket and failure to adequately supervise Jeremiah did in fact cause his death. So failure to obtain consent forms, permitting an unreasonable number of non-swimmers to attend the canoe trip. Jeremiah was not the only one who could not swim. Failing to attend the result of the pre-swim test. So these students did not attend the swimming test that they had to in order to go on the trip. All right, failing to articulate and enforce clear rules about who should wear life jackets. Of course, when these students went swimming, none of them were wearing life jackets. All right, failure to take adequate precautions at the swimming site to protect Jeremiah from the risk of drowning. And of course, that involves supervision. Finally, the OFIA guidelines mandate students have to pass the swim test to even attend such a trip. So in the results of this case, we find some interesting things. And Justice Cromwell says, if this was a case of civil negligence, the test would be met. Which is based on a balance of probabilities. But this is a criminal case. It's not enough for the Crown to prove that Mr. Mills fell below the standard. And the Crown must prove beyond a reasonable doubt that there is a failure to foresee the risks and take the steps to avoid it. So basically, this is highlighting the difference between a criminal case and a civil case, in that there's different burdens of proof. And what's particularly interesting, and we can talk about later, is that there's a very high burden of proof for people in professions like teachers or police officers, healthcare professionals. But as teachers, we do have an exceptionally high burden of proof for criminal cases. So even simple carelessness may result in tragic consequences, which may tempt judges and juries to unduly extend the reach of criminal law to those responsible. But if every departure from the civil norm is to be criminalized, regardless of the degree, we risk casting a net too widely and branding as criminals persons who are in reality not morally blameworthy. All right, giving careful attention to their fault element of the offense is essential if we are to avoid making criminals out of the merely careless. So yes, Mr. Mills was careless, but no, we're not going to put him behind bars. If everyone was tried for being that careless, then we'd have lots more people behind bars unnecessarily, right? So, and then that comes back to that high burden of proof beyond a reasonable doubt, which is what's helping Mills in this case. Our second case is Gallant versus the Thames Valley District School Board. So Gallant is the mother and father of Jordan Gallant, who tragically committed suicide in 2008 by hanging himself. And essentially here, Miss Gilbert, who works for the Thames Valley District School Board, requested some short stories. Jordan submitted an assignment via email that had the following: I just want to kill myself. I want to be painless. I don't have access to a gun, so the next best way would seem for me to hang myself. 2 weeks after submitting this assignment, he did in fact hang himself. What we do find in the details is that Gallant's mother, the day before he hung himself, did find a rough draft of the essay and asked her son about it, but did not follow up. So Ms. Gilbert's failure to report the contents of Jordan Gallant's essay to his parents constituted negligence on her part, which caused or contributed to Jordan's death. Of course, as teachers, if we see anything that smells of suicide or deep issues of mental health, it's our responsibility to, and our duty to be informing parents, informing some sort of help, enlisting help in dealing with that sort of situation. Ms. Gilbert was negligent with respect to her supervision and treatment of Jordan Gallant, and that the suicide and resulting trauma to the plaintiff was caused by her negligence. So here are the findings continued. So what needs to be understood is, in this case, what we found was the motion for summary judgment. And the summary judgment is when the defendants decide that they have enough information that they want to do a quick summary judgment. They want to resolve the issue quickly by having a short hearing with a judge. And what the result that we found here is that the application for the summary judgment was dismissed, which means no, this cannot be solved in a simple short hearing. There needs to be more. There needs to be more done here, and you're not simply going to get away with this. Okay, and the respondents' plaintiffs their legal costs were paid for. Sadly, we don't have any more information than that, but it is most likely that this case was settled outside of court, which would have resulted in some money be given by the Thames School Board to the parents of the deceased. However, what's noticed here is the reason probably for the defendants putting in this summary judgment, which would have been the school board asking for this to be dismissed, was off the precedence of Robson versus Ashworth, which says the public policy underlying the rule of public policy may have evolved and communities' views on suicide may have changed over the past 25 years. Essentially, this Robson versus Ashworth says that you cannot be given money based on the fact that somebody related to you has committed suicide. In this case, the judge has decided that that's no longer going to fly, and they need to continue with this case. So comparing Mills to Gilbert, we have a criminal case versus a civil case. However, despite there being a high failure, a high breach of duty of care in the criminal case, they were found not guilty. Well, in the civil case, what seemingly was a lower level of responsibility for the resulting death did result most likely in them being guilty. Let's cover a few things related to standards of practice for the teaching profession. This particularly relates to the case of Mills versus the Crown. And here we want to just highlight that there is a responsibility of ethics and professional judgment and practice, and that there are high levels of responsibility in the teaching profession. We need to uphold the principles of the ethical standard in these learning communities. All right. And this one, for the case of Gallant, interesting, mental health advisory from the OCT. So as this relates to the court, these are, as we said, cases of negligence, which is unintentional harm caused by the failure to eliminate unreasonable risk of injury. All right, and there's a duty of care between the teacher and the student in this case. Legal implications. Under the Education Act and regulations, teachers have a legal duty to ensure all reasonable safety procedures are carried out in the course's activity. Highly underlying all here, particularly in the case of Mills, but in both cases, all reasonable safety procedures are carried out in the courses and activities which are responsible. Under the common law, teachers are under a duty to exercise a standard of care, as David has mentioned a million times, of a careful and prudent parent when supervising students. So what is this significance to us as Ontario teachers? One thing is that teachers have to uphold a standard of care to students at all times in and outside of the classroom, particularly on field trips. But regardless of the situation, they have that high standard of care. However, teachers are given a wide burden of proof in criminal court. So more so than an average guy or perhaps a drug dealer or a gang member, you're a teacher. That means that when it comes to criminal court, particularly cases relating to students, you are given a very wide burden of proof, which is good in cases where you don't want to end up behind bars. Criminal court has a higher threshold of duty compared to civil court. As we saw, there was what seemed to be a greater breach of standard of care in the criminal case. However, that was found not guilty, and the civil court did move on and was most likely settled. So finally, a couple of notes. Teachers must be able to identify dangers and follow measures to ensure safety of students. And we need to review all board-specific excursion policies, particularly relating to the Mills case. There were many policies that were breached. Luckily, this was a criminal case, and therefore he was not found guilty. A few final thoughts. As teachers, it's our duty to have an awareness of the potential harmful and dangerous situations for students. All right, that can be mental health related, that can be physically related. Particularly, we need to be very prudent when we're taking kids on field trips around water, but around any sort of potentially harmful physical factors. Risk of potential harm and death can take on a myriad of forms, but the underlying legal obligation is our duty to exercise a standard of care of a careful and prudent parent when supervising students. Finally, that standard of care is more than a duty, and sometimes it's a matter of life or death. So it's important we don't shirk these things because they can be a lot more important than we expect. Thanks for listening, and we'll see you next time.